Yes, good evening to everybody. That is the aspirant of the PGLCET 2022 conducted by the Osmania University, and the exam is on 22nd, if I not be mistaken, of this month. Yes, read what I posted on the screen. Anyone?
सूचना
Read
का
what I
अधिकार
posted on
राइट
the
टू
screen.
इंफॉर्मेशन सूचना का अधिकार राइट टू इंफॉर्मेशन एक्ट
Yes, very good, very good. What about this one?
which one sir?
What
the
about this one?
arbitration and the arbitration and conciliation act 1996.
Very good, very good. And today, class that we are going to deal the both of them. But yesterday, a little bit, I missed the Information Technology Act, only 10 questions, and I will finish it. Then I will give the host to the today. I did not see whether the Kolikunda is present. Yeah, he is not present, but he will come anyway. Okay, now let me go through my leftover class of yesterday. Yes, the 10th question that I am referring at the time. Let me check it. Yes. I wouldn't want to see. Okay. 10th question. Dash means authentication of any electronic record by a subscriber by means of an electronic method or a procedure in accordance with the provisions of the section 3. The dash option is A, electronic signature, B option, digital signature, C option, graphic signature, D option, wet signature. And we dealt very extensively yesterday. I'm sure that you can
Option
shoot
B.
it.
Option
Option
B, sir,
B.
digital signature.
Yes, because we extensively did yesterday. That's why I told you that you can easily can shoot it. And the 11th
Good
question,
evening, sir.
yes. Answer is a D, B, digital signature for the 10th question. 11th question. Shall I proceed?
Yes, sir.
Yes sir.
11th question. Electronic signature dash is spelled in IT Act under which section? Option A, 3. Option B, 3 small a. Option C, 3 capital A. Option D, 3 capital B.
Sir, option A, sir, 3.
Wrong. Shoot the second option.
Option C,
Option
3 capital A.
Option 3, C, 3 capital A. That means option C, 3 capital A is the right answer for the 11th question. The 12th question, which section of the ITA Act deals with the legal recognition of the electronic records? Option A, section 2, option B, section 5, option C, section 6, option D, section 4.
It's option A, section 2.
No. Recognition of electronic records. The right option is
okay.
D, section 4. Am I right?
Sir, I
Okay,
don't
now next
remember this.
question. 13th question. The terminology or word electronic signature is mentioned in the IT Act how many times? Yesterday I already told you.
75. It's section D.
75 times. How many times digital signature is mentioned in the IT Act 2000? Already told you.
Yes, sir.
What is that?
75, sir.
75, the D is the option. Then the 15th question. Yes, the main objective or object of the IT Act 2000. A, according to IT Act 2000, any company can store their data in electronic storage. B option, to stop computer crime and protect the privacy of the internet users. C, to give legal recognition for keeping books of accounts by bankers and other companies in electronic form. D, to take more power to IPO, RBI and Indian Evidence Act for the restricting the electronic crime. What is that? I wrote everything. I said everything.
Yes, sir. Yes, sir.
Actually, I should miss one and I should ask you that, yes, which one is the right answer? The right answer is, all of them is the right answer.
Okay.
Is it clear?
Yes, sir. Yes, sir.
Yes.
What is IPO?
Initial public offering. Whenever the company is about to collect the capital from the market, they issue IPOs for their shares.
Good, good.
Initial public offering. Yeah.
Appreciate. 16th question. Yes, this already done. Child pornography is mentioned under section dash of the IT Act. We discussed yesterday.
Yes, 67, sir. Option C.
67 C is the right option. The seventh, the dash explicitly defines cyber caves and includes them under the term intermediaries, thus allowing the several aspects of the act to be applicable to them. In which amendment it is made as the intermediaries?
2008. Option D, sir. 2008 amendment.
Yes, it is the option D, 2000 amendment, because it's the biggest amendment. 18th question. The IT Act consists of dash section divided into dash chapters and schedules. A 94.13.4, B 93.13.4, C 94.12.4, D 94.11.4.
93-13-4, sir. Option B.
94.11.4 is the option D, is the right answer. The 19th question. The IT Act 2000 was amended by the IT Act dash. This expanded the scope and ambit of the IT Act 2000 to include all kinds of the communication devices and computer resources. This is also easy question because we already dealt yesterday.
Yes, sir.
What is that?
2008. 2008.
2008 amendment. 20th question. From filing the document, making any simple transaction, we need dash sophisticated technology, high technology, lucid technology, flexible technology.
Sophisticated technology, sir. Option A.
Right.
Then high technology is not a word.
Right.
Lucid,
We need
flexible technology.
Right.
lucid technology.
Lucid technology that we use it. That is the appropriate word.
Lucid means very clear.
Yeah, because generally that will say the language should be lucid.
Yes, sir.
The 21st question. The Act provides a legal framework for the electronic governance by the giving the recognition to electronic records and dash. A. Electronic signature. B. Digital signature. C. Proxy signature. D. Hand signature.
Digital signature, sir.
It is a digital signature only. Then 22nd question. Of course, this already we dealt it. Let me check it. Shreya Singhal versus Union of India is judgment by the two judge bench of the Supreme Court of India 2015 on the issue of the online speech and the intermediary liability in India, and which section is struck down as per the above case.
66
A.
A, sir.
66, B. 66 small a, C. 66 capital A, D. Section 66 capital AB.
Option C, sir.
Option C is the right answer for that regard. Yes, because there is a leftover would be there is. Then now today I will turn to the Kolikonda, and I edited his work, but I don't know where I saved him. I fully edited the work and put it in a problem, but doesn't matter. But I traced some of them here. Okay, now I will switch you to the Kolikonda. Sarath Babu, the ex-student and a retired English lecturer, the advocate also pursuing the second year LLM affiliated college in Usmania University, Hyderabad. Go, first question.
The first question is the first state to introduce law on right to information was A. Tamil Nadu, B. UP, C. Maharashtra, D. Gujarat.
Sir, Maharashtra, sir. Option C.
No.
Okay.
It's option D, Gujarat.
Run.
Option A is the correct answer. Tamil Nadu was the first state to introduce a law on right to information. Now, the second question is the time limit specified in the RTI Act 2005 for the Central State Information Commissions to decide on compliance is A. 15 days, B. 1 month, C. 2 months, D. No such time limit has been specified.
Option A, sir.
Option
15
B.
days.
No, sir. It's option B, 1 month, 30 days.
No.
15, sir. 15
Option
days.
D is the correct answer. No such time limit has been specified.
No, sir. RTA Act, so 30 days is the time limit to answer, sir.
Time limit specified in the RTI Act 2005 for the Central or State Information Commissions. to decide on complaints.
15
Is
days. Decide and complain. Okay.
D. No such time limit has been specified.
Okay, sir.
Third question. The first appellate authority under RTI Act should decide on first appeals. A. Within 30 days from the receipt of first appeals, in less number of days than the PIO concerned took to take a decision on the application. C. In exceptional cases, within 45 days from the date of receipt of the appeal, if the reasons are recorded. D. A and C above.
Option A,
It's
sir.
option A.
No.
Second option.
Sir, option D.
Yes, option D is the correct answer. Within 30 days from the receipt of the first appeal, but in exceptional cases, within 45 days from the date of receipt of the appeal, if the reasons are recorded. Fourth question. Central or state public commission officer may allow access to information exempted under Section 8(1) of the RTI Act 2005. Public interest in disclosure outweighs the harm to the protected interests. A. The statement is correct. B. The statement is correct, but it can be done only after the approval of appellate authority. C. The statement is correct, but it can be done only after the approval of CIC. D. None of these.
A. It's option A, sir. The statement is correct.
Pass, sir.
Option C is the correct answer. The statement is correct, but it can be done only after the approval of CIC, Central Information Commission. If the interest outweighs the harm to the protected interest, then CIC can take a decision to disclose it. Fifth question. Who does right to information mean? What does right to information mean? A. Inspect works, documents, records. B. Take notes, extract or certified copies of documents or records. C. Take certified samples of material. D. All of the above.
D, sir. All of the above.
Yes, option D is the correct answer. All of the above. Sixth question. What is the maximum amount of penalty under RTI Act 2005 that can be imposed on CPIO? A. 300 rupees. B. 25,000. C. 75,000 rupees. D. 1 lakh rupees.
I'll guess, sir. It should be D.
No. Option B is the correct answer. It is 75,000. Sorry,
C.
25,000. 25,000.
Okay.
Seventh
Sir,
question.
CPIO
With
means, sir?
reference,
CPIO.
CPIO means Central Public Information Office.
Okay, sir. Thank you, sir.
Seventh question. With reference to the RTI Act, which of the following statements is or are true? A. A third party is a person other than citizen making a request. B. Third party includes a public authority also. C. Both A and B are true. D. Neither A and nor B are true.
C, sir. Both A and B are true.
Yes, option C is the correct answer. Both A and B are true. Eighth question. The basic object of the Right to Information Act 2005 is A. To empower the citizens. B. Promote transparency and accountability in the working of the government. C. Contain corruption. D. All the above.
Option D, sir. All of the above.
Yes, option D is the correct answer. All of the above. To empower the citizens, to promote transparency, and to contain corruption. Now, ninth question is, which of the following is not correct? The CPIO cannot seek the assistance of any other officer for proper discharge of his or her duties. B. The CPIO may seek the assistance of any other officer for proper discharge of his or her duties. C. Every CPIO shall deal with requests from persons seeking such information and render reasonable assistance to the persons seeking such information. D. CPIO should provide information if not expected within 30 days.
Option C, sir.
Option
which
A.
is not correct.
Oh, not
Which is
correct. Okay.
option A, sir.
Yeah,
Option
cannot
A
see.
is the correct answer. The CPIO cannot seek the assistance of any other officer for proper discharge of his or her duties is not correct. He can seek the assistance. 10th question. Under RTI Act 2005, the information is provided to the applicant free of cost. A, if the applicant is a BPL person. B, where a public authority fails to provide information within 30 days of receipt of application. 3, where a public authority fails to provide information within 45 days of receipt of application. A 1 only. B, 2 only. C, 3 only. D, both 1 and 2.
D, sir, is both 1 and 2.
Yes, option D is the correct answer, both 1 and 2. If the applicant is a BPL person, if public authority fails to provide information within 30 days of receipt of application. Now, 11th question. Under RTI Act 2005, which of the following statements is correct? 1. Information, the disclosure of which would cause a breach of privilege of parliament can be denied. 2. Information, the disclosure of which would cause a breach of privilege of state legislature can be denied. 3. Information, the disclosure of which would cause a breach of privilege of parliament cannot be denied. 4. Information, the disclosure of which would cause a breach of privilege of state legislature cannot be denied. A. 1 and 2 only. B. 2 and 3 only. C. 3 and 4 only. D. 4 and 1 only.
1 and 2 only. Option A.
Yes. Option A is the correct answer. 1 and 2 only, which causes privilege to both to parliament and state legislature, that can be denied. 12th question. As per section 12(2) of RTI Act 2005, the Central Information Commission shall consist of A. The Chief Information Commissioner and such number of Central Information Commissioners not exceeding 10 as may be deemed necessary. That B. The Chief Information Commissioner and such number of Central Information Commissioners not exceeding 5 as may be deemed necessary. C. The Chief Information Commission and such number of Central Information Commission not exceeding 2 as may be deemed necessary. D. The Chief Information Commissioner and such member of Central Information Commissioners not exceeding 3 as may be deemed necessary.
It's 12A, sir.
Yes. A 1 only. B 1 and 2 only. C 1 and 3 only. D all the above. A, it is A. Answer A is the correct answer. 1 only. The Chief Information Commissioner and such number of Central Information Commissioners not exceeding 10 as may be deemed necessary. Next, 13th question. Who can place an Information Commissioner under suspension? 1. The President of India. 2. The Prime Minister of India. 3. The Chief Justice of India. A. 1 only. B. 1 and 2 only. C. 1 and 3 only. D. All the above.
A, sir, 1 only.
Yes. The President of India only can remove the Chief Information Commissioner, and place under suspension. 14th question. Choose the correct option as per section 13(5) of RTI Act 2005. The salaries, A, the salaries and allowances payable to and other terms and conditions of service of Chief Information Commissioner is the same as that of the Chief Election Commissioner. B, the salaries and allowances payable and other terms and conditions of service of Chief Information Commissioner is the same as that of the Chief Justice of High Court. C, the salaries and allowances payable to and other terms and conditions of service of Chief Information Commissioner is the same as that of the Justice of High Court. D, the salaries and allowances payable and other terms and conditions of service of Chief Information Commissioner is the same as that of Justice of Supreme Court.
It's option A, sir.
This option A is the correct answer. It is equal to Chief Election Commissioner's salary. 15th question. It shall be the duty of the Central Information Commission to receive and inquire into a complaint from any person. 1. who has not been given a response to a sequel for information or access to information within the time limit specified under RTI Act 2005. 2. Who has been required to pay an amount of fee which he or she considers unreasonable. 3. Issuing summons for examination of witnesses or documents. A. 1 only. B. 2 only. C. 3 only. D. All the above. What is the correct answer?
Sir, all of the above.
Yes, it is all of the above. The answer is all of the above.
Yes,
You
now I
can do
turn
all
to the Sri Vidya Motamari. Yes, continue it.
Yes, sir. When the conciliator receives factual information concerning the dispute from a party, option A, he shall disclose substance of that information to the other party. Option B, he shall not disclose substance of that information to the other party. Option C, he shall or shall not disclose substance of the information to the other party, depend upon his discretion. Option D, none of the above.
It's option D, none of the above, ma'am.
No, option A is the correct answer. He shall disclose substance of that information to the other party. Second question. What are the conditions for commencement of conciliation proceedings? Option A. The party initiating conciliation shall send to the other party a written invitation to conciliate before brief identifying the subject of the dispute. Option B. The party initiating conciliation should receive a reply within 30 days from the date on which he sends the invitation to the other party. Option C, acceptance writing the invitation to conciliator by the other party. If the other party rejects the invitation, there will be no conciliation proceedings. Option D, all the options are correct.
Option D.
No, option D is not correct.
Option A then.
It's option B. The party initiating conciliation should receive a reply within 30 days from the date on which he sends the invitation to the other party. The third question, the mandate of an arbitration shall, option A, be terminated by the death of any party by whom he was appointed. Option B, be terminated by the death of the counterparty. Option C, not be terminated by the death of any party by whom he was appointed. Option D, none of the above.
It's option A, ma'am.
Okay.
Say loudly.
It's option A.
C. Option C.
Yes, option C is the correct answer. The next question. Arbitral tribunal means option A, only panel of arbitrators. Option B, the sole arbitrator or a panel of arbitrators. Option C, more than one arbitrator. Option D, only a sole arbitrator.
More than one arbitrator. Option C.
I think there will be only one arbitrator. I think
Yeah.
D is the correct answer.
There can be a panel of arbitrators also. Option B, both a sole arbitrator or a panel of arbitrators. And next question, fifth one.
So
The-
more than one. Okay.
A sole arbitrator or a panel of arbitrators?
Option B is the correct.
Okay.
Yeah. Fifth question, the purpose of Arbitration Act is to provide quick redressal to dash by private arbitration. Option A, family disputes. Option B, service disputes. Option C, commercial dispute. Option D, political disputes.
Commercial
It's
dispute.
option
Option
A.
C.
Yes, yes, simple question. It's for commercial disputes.
For family, we have got family courts.
Yes.
Mediation. Mediation.
Mm.
Yeah.
The next question. The arbitration agreement is in writing if it is contained in option A, an exchange of letters, telegrams, or other means of telecommunication which provides a record of agreement. Option B, an exchange of statements of claim and defense in which the existence of the agreement is alleged by one party and not denied by the other. Option C, a document signed by the parties. Option D, all options are correct.
All options are
Option
correct.
D.
B
Option B, madam.
should not be denied by other party.
No, option D is the correct answer. All the options are correct.
Okay.
Yes. The next question, seventh one. As regards the determination of rules of procedure, the arbitral tribunal shall not be bounded by option A, Indian Evidence Act 1872, option B, the Code of Civil Procedure 1908, option C, both A and B, option D, none of the above.
Both A and B. Option C.
Again, read the question, shall not be bounded by.
Should not
None
be
of them.
bounded by.
So option D, none of
None
them.
of the above, madam.
Yes, none of the above is the correct answer.
Rules procedure. Okay.
Eighth question.
I think this means the beyond the law we are settling. No?
Beyond the law, out of the code. Okay. What twisted one? Yeah.
Shall I continue?
Yeah, please.
Yeah, go.
Eighth
Yeah,
one. Where the place of arbitration is situated in India. An international commercial arbitration. Option A, any designation by the parties of the law or legal system of a given country shall be constrained unless otherwise expressed as directly referred to the substantive law of that country and not to its conflict of laws rules. Option B, filing any designation of the law under clause A of subsection 1 of section 28 by the parties, the arbitral tribunal shall apply the rules of the law it considered to be appropriate given all the circumstances surrounding the dispute. Option C, the arbitral tribunal shall decide the dispute in accordance with the rules of the law designated by the parties as applicable to the substance of the dispute. Option D, all of the above.
Option D, madam. All of the above.
Yes, correct answer. Ninth one, if the award is made within a period of from the date the arbitral tribunal enters upon the reference, the arbitral tribunal shall be entertained to receive such amount of additional fees as the parties may agree. Option A, within 6 months, option B, 12 months, option C, 3 months, option D, 9 months.
Option A, 6 months.
Yes, option A, 6 months is the correct answer. 10th question, on what grounds the award may be challenged before the court? Option A, invalidity of the arbitration agreement. Option B, parties applying was not given proper notice to the appointment of the arbiter or the arbitral proceedings or was otherwise unable to present his case. Option C, incapacity of the party. Option D, all the options are correct.
D, all the
Option D,
options are
madam.
correct.
All the above.
Yes, all the options are correct. 11th question, unless otherwise agreed by the parties, a party with notice to the other party may request from the receipt of the arbitral award, the arbitral tribunal to make an additional arbitral award as to claim presented in the arbitral proceedings but omitted from the arbitral award. Option A, within 30 days, option B, within 45 days, option C, within 60 days, option D, within 15 days.
Option A, within 30 days.
Yes, option A is the correct answer. The next question, when an arbitral proceeding shall be terminated. Option A, final arbitral award. Option B, interim award. Option C, where the arbitral tribunal issues an order for the termination. Option D, only A and C are correct.
Option D, only A and C are correct.
Yes, the final arbitral award or when the arbitral tribunal issues an order for the termination. Then only it can be terminated.
Yes.
13th question, the number of conciliators required in the conciliation. Option A, where there is more than one conciliator, they ought as general rule to act jointly. Option B, there shall be one conciliator unless the parties agree that there shall be 2 or 3 conciliators. Option C, both A and B are correct. Option D, none of the above.
Option C, both A and B are correct.
Yes, option C is the correct answer. Next one. The communication between conciliator and parties may. Option A, meet or communicate with the parties together or with each of them separately. Option B, meetings with the conciliator are to be held at such place as determined by the conciliators after consulting with the parties. Option B, orally or in written. Option D, all the options are correct.
Option D, all of the above.
Yes, all the options are correct. 15th one, the Arbitration and Conciliation Act 1996 has not repealed the following act. The Arbitration Act 1940, the Sikh Industrial Companies Special Provision Act 1985, the Foreign Award Recognition and Enforcement Act 1961, the Arbitration Protocol and Convention Act 1973.
Option C, madam.
1937. Pardon?
Option C,
B.
foreign awards.
No,
Sir,
option B is the
madam,
correct answer.
Option B.
Yes, option B is the correct answer. The next question, 16th one. What is application and scope of the conciliation? That is option A, the dispute arising out of the legal relationship, whether contractual or not, and to all proceedings relating thereto. Option B, the disputes arising out of business relationship, whether contractual or not, and to all proceedings relating thereto. The dispute arising out of love relationship, whether contractual or not, and all proceedings relating thereto. Option D, disputing arising out of family relationship, whether contractual or not, and to all proceedings that relating thereto.
Option A, ma'am.
Yes.
Business relationship, yeah.
Yes, legal relationship and
Yeah.
whether contractual or not, and all the proceedings relating thereto.
When you answer the question, speak loudly because you are having the smartphone.
Yes, sir.
Read.
Yes, sir.
The correct answer is option A. 17th
Yes.
question. In arbitration, parties cannot appoint even number of arbitrators, while in conciliation, the number of conciliators can. Option A does not matter whether odd or even. Option B, odd only. Option C, even only. Option D, none of these.
It's option
Option
A,
A.
ma'am.
Yes, it does not matter whether odd or even for conciliators. And 18th question. The arbitral tribunal may fix the amount of the deposit or supplementary deposit as an advance for the cost. What are the rules relating to such deposit? Option A, where one party fails to pay his share of the deposit, the other party may pay that share. Option B, where the other party also does not pay the aforesaid share in respect of the claim or the counterclaim, the arbitral tribunal may suspend or terminate the arbitral proceedings in respect of such claim or counterclaim, as the case may be. Option C, the deposit shall be payable in equal shares by the parties. Option D, all of the above correct.
Option D, all of the above are correct.
Yes, all of the above is the correct answer. And the 19th question, correction and interpretation of award can be made dash from the receipt of the arbitral award. Option A within 30 days, option B within 60 days, option C within 15 days, option D within 45 days.
Within 30 days, option A.
Yes, I think it is repeated.
It was related to
No.
appeal actually. Now it is correction.
Yes.
The previous was related to appeal.
Yes. Yes.
Okay. The last question, 28. The award under the fast track procedural shall be made. Option A within a period of 3 months from the date the arbitral tribunal enters upon the reference. Option B within a period of 6 months from the date of arbitral tribunal enters upon the reference. Option C within a period of 9 months from the date the arbitral tribunal enters upon the reference. Within option D within a period of 1 month from the date the arbitral tribunal enters upon the reference. Whether it is 3 months or 6 months or 9 months or 1 month.
It's option A, 3 months.
Then fast track
No.
generally means 1 month.
Within okay, 1 month. Okay,
You the
option
answer.
D.
No, it's option B, 6 months. Within a period of 6 months from the date the arbitral tribunal enters upon the reference.
It is called as fast track.
Yes, Kolikonda,
Yes.
you can continue it from the 15th question. 15th question you dealt it, I believe.
Yes, it shall be the duty of the Central Information Commission. Again, we have come to RTI. It shall be the duty of the Central Information Commission to receive and inquire into a complaint from any person, one who has not been given, we have already completed. 16th question, that is also over.
Completed. From where you left?
Yes, 17th question, sir.
To my knowledge, you continued up to 15th. Okay. Continue 16th.
Okay. The Central Information Commission, while inquiring into any matter under Section 18 of RTI Act 1, cannot compel a person to give written evidence on oath like a civil court does. 2, can compel a person to give written evidence on oath like a civil court does. 3, can enforce the attendance of a person like a civil court does. Options: A, 2 and 3 only; B, 3 and 1 only; C, 1 and 2 only; D, 1 only. This is about Central Information Commission's power under Section 18 of RTI Act.
Sir, it's option A, second and three only.
Yes, option A is the correct answer. It can compel a person to give written evidence and it can enforce the attendance of a person like a civil court. Now, 17th question. The Central Information Commission, while inquiring into any matter under Section 18 of RTI Act 1, cannot requisition any public record or copies thereof from any court or office. 2, can requisition any public record or copies thereof from any court or office. 3, cannot receive evidence on affidavit like a civil court does. A, 1 only; B, 3 only; C, 2 only; D, 1 and 2 only.
C, sir.
Yes, option C is the correct answer. Can requisition any public record or copies thereof from any court or office. It can request for any copy from any court or office. Now, 18th question. Who can file an appeal against the decision of CPIO under RTI Act? 1, the information seeker. 2, the third party aggrieved by the order of CPIO. 3, any citizen. Options: A, 1 only; B, 1 and 2 only; C, 3 only; D, 2 and 3 only.
One and three, sir.
So option B is the correct answer. 1 and 2 only. The information seeker as well as the third party aggrieved by the order of CPIO. 19th question. Which one of the following statements is true? 1, in any appellate proceeding, the onus lies on CPIO to prove that he acted diligently. 2, in any appellate proceedings, the onus lies on information seeker to prove that the CPIO did not act diligently. 3, the Information Commission does not have powers to recommend disciplinary action against CPIO. A, 1 only; B, 2 only; C, 2 and 3 only; D, 1 and 2 only. Shoot your answer.
Sir, it's option C.
Say loudly.
It's option C, sir.
Option A is the correct answer. In any appellate proceedings, the onus lies on CPIO to prove that he acted diligently. 20th question. The burden lies on him only, CPIO only. 20th question. Which of the following statements is true? 1, which information sought for is in respect of allegation of violation of human rights by security agencies. It shall only be provided after the approval of central government. 2, information in respect of allegations of violation of human rights by security agencies is fully exempt from disclosure under RTI Act. 3, when information sought for is in respect of allegations of violation of human rights by security agencies, It shall only be provided after the approval of Central Information Commission. A, 1 only, B, 2 only, C, 3 only, D, 1 and 2 only.
D, 1 and 3 only.
Any other option? I think we have
Only
already
two.
come
Only
across.
two.
It's B.
Option C is the correct answer. 3 only. When information sought for is in respect of allegations, then only after the approval of Central Information Commission only it can be issued. 21st question. Which of the following organizations is included in Schedule 2 of the RTI Act? A. Border Security Force. B. Central Reserve Police Force. C. National Security Guards. D. All of the above.
D, sir, all of the above.
Yes, all these three, Border Security, Central Reserve, National Security Guards are involved in Schedule 2. 22nd question. The provision relating to suo motu disclosure is contained in A, Section 4 of the RTI Act, B, Section 11 of the RTI Act, C, Section 22 of RTI Act, D, Section 24 of RTI Act.
Section 4 of RTI Act.
Yes, it is in the Section 4 of RTI Act. Now, 23rd question. RTI Act 2005 came into force on A, 12th October 2005, B, 15th August 2005, C, 15th June 2005, D, 1st November 2005.
First
Option A,
November
sir.
2005.
What is
First
the
November
option?
2005.
Option A is the correct answer. It is 12th October 2005. Came into effect from that date. 24th question. Which of the following is not come under the definition of information under RTI Act 2005? A. Logbooks. B. File notings. C. Data material held in any electronic form. D. Circulars.
It's option B, file notings.
Yes, option B is the correct answer. File notings do not come under the definition of Information Act. 25th question. The officer designated by the public authorities and all administrative units or officers under it to provide information to the citizens requesting for information under the Act is known as A. Appellate Authority, B. Chief Information Commissioner, CIC, C. Public Information Officer, BIO, D. Assistant Public Information Officer.
It's option A, appellate authority.
B. Option B.
Option C is the correct answer. First, it goes to Public Information Officer only.
PIO.
PIO.
Okay.
Every office has
Yes,
Public
yes.
Information Officer.
Yes, it's my turn. First question. Arbitration Conciliation Act 1996 Act ID A 1992-62, B 1996-26, C 1997-26, D 1996-27. Which one is the correct option? ID.
Option C, sir. Option C, sir.
Wrong. ID, I
Option
already
B,
told
sir.
you that.
Option
On the
B,
which
sir.
section and the which year the act number will come. The year is 1996. We should just compare it. Which one is the right answer?
Option B, sir.
Option D is the correct answer.
Option B is the right answer, 1996 and Act number 26.
26.
Second question, the above act is repealed and replaced by dash. A, the Arbitration Conciliation Act Amendment 2021. B, the Arbitration Conciliation Act Amendment 2021. C, Arbitration Conciliation Act Amendment 2022. None of the above.
Option B, sir.
Say full.
The Arbitration Cancelling Act Amendment Act of 2000.
The Arbitration Conciliation Act Amendment of 2021 feedback already I displayed over there. But anyway, come to the matter of the third question. Due to rise in the population, industries also developed significantly, and as a result of it, dash also increased. A. Civil disputes. B. Business disputes. C. Commercial disputes. D. Financial disputes. Easy question.
Financial disputes.
Sir, commercial dispute, sir.
It is a commercial dispute. Fourth, the main purpose of the dash is to provide the speedy justice to the parties. A. Mediation. B. Conciliation. C. Mini trial. D. Arbitration.
Mediation, sir.
Mediation.
Yeah.
A is the right answer. Mediation is the right answer for that question.
What is the
Okay. Is it a mediation? No. Arbitration is the right answer. Arbitration is
Okay.
the right answer for the fourth question. Is it clear?
Yes, sir. Yes, sir.
Yes, sir.
What is the full form of this acronym? UNICETRAL. United Nations Commissioners on the International Trade Law. Union Nation Commission on International Trade Law. C. United Nations Commission on the Internal Trade Law. D. United Nations Commission on the International Trade Law.
Sir,
Is
option D, sir.
Option D is the right
D.
answer. It is the United Nations Commission on the International Trade Law. The sixth question. It is based on the UN model as to equate with the law adopted by the which act or international instrument? A. UNICEF. B. UNICETRAL. C. NHRC. D. TRIPS.
Option B, sir. Unilateral.
It is a UNICETRAL. It is based on that one. It is kind over there. Then seventh question. Dash of the Arbitration and Conciliation Act empowers the arbitral tribunal to grant interim relief to the contracting parties. A. Section 14. B. Option Section 15. C. Option Section 16. D. Option Section 17.
Option 16, sir. Option C.
Wrong.
It's option A, sir, section 14.
Wrong. The right answer is D. Section 17. Seventh question, right answer is D. 17. Section 17. That is the right answer for that question. Then the eighth question, Section 10. Number of arbitrators 1. The parties to the free to determine the number of the arbitrators, provided that such number shall not be number A. Proportionate. B. Odd. C. Uneven. D. Cardinal.
It's option B, odd.
Cardinal, sir.
Did you understand the question first? Section 10 clearly says number of arbitrators.
Odd, sir. Option B.
Wrong.
Then it should be
Not
even,
be
sir.
Then it should be the
proportionate.
even.
Even,
Shall
sir.
not be even. So that is
Yeah,
the
yeah.
condition means.
There shall
There you have
not
to
be.
understand.
You are not observing. Shall not be.
Yes, sir. Yes, sir.
Because the even numbers means divided by 2. Odd numbers means
Yeah.
not divided by 2.
Yeah.
It should be odd, but you have to understand the statement shall not be
B.
even in the.
The ninth question. The act is divided into 4 parts. Choose part 1. Answer what it is explained. Part 1, part 2, part 3, part 4. A. Conciliation. B. Supplementary provision. C. Applies to the place arbitration in India. The award granted is treated as a domestic award. D. Enforcement of the foreign awards. Now here options I have given. 1A, 2B, 3C, 4D, 1B, 2C, 3D, 4A, 1C, 2D, 3A, 4B, 1C, 2A, 3D, 4B. Which one is the right option?
I think option A is the correct answer.
Wrong. Second option. At any time it will be closed because time is up. And the
Yes,
tomorrow
sir.
class that I will do the mixed one. Tomorrow is the last
Option D,
class.
sir.
And I believe that we all three will be present tomorrow. If God
Yes, sir.
permits us.
Yes,
It's
sir.
option A, sir.
Wrong.
Wrong.
Here I give the feedback. Now you can tell me. Part 1 applies to the place of arbitration in India. The award granted is treated as a domestic award. Part 2, enforcement of the foreign award. Part 3, conciliation. Part 4, supplementary provisions. Then which is the correct one?
C.
C is the correct one. The type of the 10th question. The type of the arbitration list below 4. One among them is not a type of arbitration. Number 1, municipal arbitration. B, international and commercial arbitration. C, institutional arbitration. D, statutory arbitration.
C, institutional arbitration.
Wrong. Read the question.
Option
Which
D,
is
sir.
among them is not a type of arbitration.
Municipal arbitration.
Municipal arbitration is not there. It is a domestic arbitration. So I changed the municipal arbitration from the domestic arbitration. Okay, which one of the not the type of arbitration? Again, A, ad hoc arbitration. B, fast track arbitration. C, look sniff arbitration. D, flip arbitration.
Flip, sir.
Then what would be the right one?
Okay.
What would be the right one?
Fast track attribution.
No, it is a
Ad
flip-flop
hoc arbitration.
arbitration.
Ad
It is a flip-flop arbitration. I changed the sequence. So the answer for the 11th question is
D, sir.
D. Of course, they are here. I gave the type of the arbitration. So domestic arbitration, international and commercial arbitration, institutional arbitration, statutory arbitration, ad hoc arbitration, fast track arbitration, look-sniff arbitration, flip-flop arbitrations. Now, generally cases of civil rights where the remedy is the damage referred to the arbitration but dash of the act gives the list of the such cases which cannot be submitted to arbitration. Section 3.2, Section 2C, Section 2.3, Section 2.4, the D option.
Section 2.3, sir. C, option C.
It's the right. It's the Section 2, Class 3 is the right. Haryana Telecom Limited versus Starlight Industries says about what? A. Start-up proceedings of any company. B. Winding up proceeding of any company. C. Retrenchment proceeding of any company. D. Insolvency proceeding of any company.
Insolvency of proceeding. D, sir.
Wrong.
Option B, sir. Winding up proceeding.
Winding up the proceeding of any company is the right answer for that question. The 14th question. The preamble of the act is interpreted as follows. It is an act to integrate and amend the law relating to dash national arbitration, B. International commercial arbitration, C. Domestic arbitration, D. Enforcement of the foreign arbitral award.
Option A, sir.
Option
National
A is the
arbitration.
right answer. That is the national arbitration, the act to integrate and amend the law relating to the national arbitration only. The 15th question. Usually all the disputes in which the civil rights of a citizen are infringed and the disputes falling within the jurisdiction of the civil court can be referred to arbitration. But the disputes which are related to dash are not arbitrable in India. A. Morality, B. Public policy, C. Status, D. All of the above.
All of the above, sir.
All of the above is the right answer. 16th question. The doctrine of competence enshrined in the dash of the Arbitration and Conciliation Act of 1996, or in other words, we can call it the Arbitration Act within parentheses, and the legislative intent to restrict the judicial intervention at pre-reference stage. The Supreme Court held that the issue of limitation would be decided by an arbitrator. A. Section 13, B. Section 14, C. Section 15, D. Section 16.
Section 14, sir.
15, sir.
Section 14 is the right answer for that question. It is decided competence. This is a doctrine where it can be used over there in the section 14. And the 17th question, at any time it will be stopped. The Supreme Court observed that the issue limitation is a justification issue which should be decided by the arbitrator in terms of the section 16 of the Arbitration Act, not before the High Court at the pre-reference stage under the section 11 of the Arbitration Act. The Supreme Court observed that once the arbitration agreement is not disputed, all issues including the jurisdictional issues are to be decided by the arbitrator, was observed in the case of dash Tulsi Narayan Garg case, B. Hindustan Construction Company Limited case, and C. Uttarakhand Purv Sainik Kalyan Nigam Limited, D. The Oriental Insurance Company Limited, others.
Tulsi
Option
Narayan.
D, sir. Oriental Insurance Company.
Wrong.
Option A, sir. Tulsi Narayan.
Then it should be B, sir. Hindustan Construction Company.
Wrong.
Option C, finally.
It's the Uttarakhand Puri Sainik Kalyan Nigam Limited versus Northern Coalfield Limited. Then 18th question, at any time it can stop. Before it stop, I can make it a speed and fast training. 18th question, the two members bench of the Honorable Mr. Justice Robinson Farley Norman and Honorable Justice Vineet Saran bench has struck down a clause which required the 10 pre-deposit of the claim amount prior to the invoking the arbitration proceeding was decided in the case of A. National Highway Authority of India, B. Brahmani River Pallets Limited, C. Measures E-Common Tele Limited, and D. Rashid Raza versus Sadaf Akhtar.
So never
Option A,
heard
sir.
about it.
10% deposit should be eliminated. Earlier they want to claim it means they have to deposit 10%.
Okay.
It's
For
option
D,
D,
sir.
sir. Rashida Raza versus Sadafa.
Option D, sir.
It is measures Ecom Tele Limited versus Punjab State Welfare Water Supply and Sewage Board. That in that case, it is decided over there. The Supreme Court, 19th question, held that in this case, parties have agreed to as the Bhubaneswar as the place for the arbitration proceedings. Therefore, the parties intend to exclude the jurisdiction of all other courts. Therefore, the Supreme Court held that the Madras High Court is not entitled to exercise the jurisdiction under the Section 11, Class 6 of the Arbitration and Mediation Act of 1996. A. Brahmani River Palace Limited. B. Mahangar Telephone Nigam Limited. C. Vinod Bhailal Jain. And D. Swastik Gas Private Limited.
Option B, sir. Mahanigam Telephone Nigam Limited.
Wrong.
Option D, sir. Swastik Gases.
Wrong.
A. Option A.
Brahmani River Pellets Limited versus Kamachi Industries Limited, where it is clearly mentioned that which the party agreed over there, that is only the jurisdiction of the arbitral award, but not the High Court or the Supreme Court having any jurisdiction to change the party's option of the jurisdiction. So 20th question. It was held by the court that once the arbitrator becomes ineligible by the law, another arbitrator cannot be nominated by him. A person who is ineligible statutorily cannot nominate an arbitrator. It has been classified in the earlier judgment that a person who has an interest with regard to the outcome of the arbitration proceedings is not eligible to be an arbitrator was decided in the case of dash Y.K. Gupta and others company, and B. ITD LTD. Yes, ITD. Yes.
Cementation India Limited versus
सारे जहां से अच्छा हिंदुस्तान हमारा। जय हिंद।
Jai Hind.